Sanibonani ninjani molweni afsheni thobela today's LME 3701 research topic for semester 1 of 2024. Now, without wasting the time, let's go straight to the business of the day. We won't be talking now about Tunitin. We'll talk about those stuff later on part 2. On this part, we'll only specialize with the research topic and give you some clue about how you can answer the question. So the research topic here, we have the research topic. Let's read it together. You work at a law firm that specializes in a family law. You are consulted by a man with his male life partner. State down. You must note down that we are talking about a man who has a relationship with another man in a love partnership. They explain to you that they had just had a baby through a surrogate. It means that they have found someone, a woman, so that they can have a baby. And when they went to the Department of Home Affairs, they were not allowed to register as the child's parents due to the fact that they were not married at the time of the birth. You are tasked with researching the law on the rights of parents of children conceived through surrogacy. You have to focus on the rights of the parents. Of course, this will include the relevant constitutional rights, whether a historical approach, whether you choose a historical approach or comparative approach. So yeah, downwards here we have a historical approach and the comparative research approach. So in the historical research approach, you have to research the history of surrogate and how it was adopted into our constitution, how it works, and what are the parent responsibilities under surrogate. But when we talk about comparative, it's when you compare the law of surrogate in South Africa with the law of another country. For example, here they given you that you must research the law of England, which the law of England is very simple because there are a lot of websites that specializes with the England law. So it will be much easier for you to find the England law. However, today we are not going to start with a historical or comparative. We will just give you a tips on how you can start to approach the scenario. Firstly, you must start with the Constitution of Republic of South Africa, which is the primary legislation for anything you want to write about. You must know this is a primary legislation. This is a primary statute. Yeah. Then you must note down the section of the Constitution, which is section 12, under the Bill of Rights, which stated clear that everyone has the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction, to security in and control over their body, and not to be subjected to medical or scientific experience without their informed consent. So a woman who is part of the surrogacy will be likely to be protected by this section, which is section 12 of the Constitution. So you must note down this section. It's very much important for surrogate. Another important section is the section 28 of the Constitution under the Bill of Rights, chapter 2, which is stated very clear that a child's best interests are of paramount importance in every matter concerning the child. So you must note down this section, section 28, subsection 2, that the child's best interests are of a paramount importance in every matter concerning the child. So even if when you are going to be doing some historical research or comparative, you must know that this section is applicable and you must apply it throughout the portfolio. Remember, LME is a very, very, very important portfolio. If you don't pass it, if you fail LME, you are not allowed to register the fourth modules. So it's very much important to pass this portfolio. Then we have a document here which I love dearly. which I will use it as a journal article, and I love this part here. It said, every child has his or her own dignity. This one is supplementing section 28, which I was reading. If a child is to be constitutionally imagined as an individual with a distinctive personality and not merely as a miniature adult waiting to reach full size, he or she cannot be treated as a mere extension of his or her parents, umbilically destined to sink or swim with them. I love this one. Now, you will understand when we go to part 2, part 3. This document is a very important document that you must read. Without having knowledge about this document, I don't think that you will be able to write about surrogacy. It states about the nature of surrogacy. And this is a journal article. It says surrogacy in its most basic sense is a situation where one woman bears a child for another. So this is a definition of a surrogacy. The word surrogate means substitute, and a woman may agree to act as a substitute mother for many reasons. It has been suggested that the prefix surrogate suggests that in some way the woman carries the child is not a real mother. Other terms used to describe the surrogate include hostess mother, hoster mother, and even plumbing. There are two main types of surrogacy agreements. Total surrogacy, where the surrogate is not biologically related to the child, and partial surrogacy, where the hair ovum is used. Commissioned adoption, where an infertile couple contracts with a surrogate to carry a child unrelated to either the surrogate or themselves, is not permitted. Surrogacy is a means to provide families with children that are biologically related to them, has received scant attention over the decades, despite it being a reality of a world in which infertility is rife and adoption process. Surrogacy became a common topic of conversation in South Africa, in a South African household in 1987 when Pat Anthony, a Tsanin grandmother, gave birth to her own children. Anthony's daughter, Karen Ferreira George, then adopted the children and raised them as her own. Although surrogacy has remained a practice in South Africa, the sensationalism surrounding the birth of the Ferreira George triplets has remained unparalleled since. Despite this, a wealthy of article on surrogacy followed the birth. Another document stated very clear that surrogate motherhood may not take place for commercial reasons as a source of income. The surrogate mother must have a documented history of at least one pregnancy. Spouses, civil union partners, same-sex or heterosexual life part permanent partner, or a single person may be commissioning parent, provided that they are or he or she is permanently or irreversibly unable to give birth. The parties must conclude and sign a valid surrogate motherhood agreement. The agreement must be entered into in South African while the commissioning parent or at least one of them, as well as the surrogate mother and her spouse, civil union partner, or partner in a permanent relationship, are domiciled in South Africa. If the commissioning parent is a single person, he or she must be domiciled in South Africa. If a commissioning parent or the surrogate mother is part to a marriage, civil union, or permanent relationship, his or her spouse, civil union partner in the permanent relationship must give written consent and must become a party to the agreement. The agreement must be confirmed by the High Court within whose area of jurisdiction the commissioning parent are domiciled or habitually resident. The surrogate mother may not be artificially fertilized until the agreement has been confirmed. The procreation of the child must be effected by the artificial fertilization of the surrogate mother within 18 months after the confirmation. The gametes of both commissioning parents must be used for artificial fertilization, or if that is not possible due to biological, medical, or other valid reasons, the gametes of at least one of them must be used. If the commissioning parent is a single person, his or her gametes must be used. Relationship between the child and the birth mother and between the child and the commissioning parents. Okay, let's avoid this one. There are many, but if you can go and read this book, you'll understand some of the surrogate. I know that you get a clue now. Another valid information: the only means by which parents commissioning a baby through the surrogacy process could acquire parental rights and responsibilities in respect of such a child was to adopt it through the normal channels. This process was fraught with its own difficulties. Commissioning parents may prefer surrogacy arrangement to adoption for a number of reasons. Because the 9-month period of gestation associated with the pregnancy of a surrogate may be far shorter than the waiting period associated with an adoption. Surrogacy allows for the possibility that one or both of the commissioning parents may be biologically related to the child, and commissioning parents are not subject to the age limits associated with adoptive parents. Another thing is that surrogacy is more complex than adoption, and the surrogate motherhood agreement cannot be seen as just an ordinary contract. Because of the unique mixture of contractual and personal interest, choosing one model over the other will not allow for dealing with the situation as effectively or temporarily as possible. A mixed model, encasing aspects of both models, should be designed. Furthermore, the fact that the general principle of the law of contract alone were deemed insufficient to regulate surrogacy means that a blending of the contract law and family models was what the law commissioning intended. Academic research should thus be conducted on how to devise a surrogacy-specific model suited to the current South African legal climate. And I can say a lot about the surrogacy. I can provide you with more information and more documents, but you must know that you have to contact us to be provided such a document. So we'll do part 2, where we'll go on and be very patient with us, because we deal with more modules. So we may be uploading part 2 next week or next week, but it's up to you to contact us directly so that we're able to solve your problem faster. So I have shed a light about the surrogacy on this part 1, and I hope that I will share another light on part 2.